This is the Business of College Sports podcast with your host, the founder of businessofcollegesports.com, Christy Dosh. Find her on Twitter and Instagram at SportsBizMiss.
Hello, everyone. Welcome back to the Business of College Sports. We haven't had a podcast or a video here in a while. I've been too busy writing things and getting my book out to be able to stop on and talk about things. But I was at a conference last week with one of my favorite attorneys, an immigration attorney, Ksenia Maiorova, who, if you followed me at all, you know that I quote her all the time when it comes to international athletes and what they can and cannot do with NIL and with revenue sharing. And we had so many questions come up last week, including questions from athletic directors and folks in athletic departments who are still trying to figure out the answers to this and how to navigate it. So I asked Ksenia, can we just jump on and do something together? And we're going to try to hit the stuff that I see people asking the most often. Some of you send in questions by social media, so I'm going to try to get to all of those as well. Ksenia, thank you for joining us.
Thanks so much for having me again. It's great to see you.
Okay, let's begin at the beginning, since some people might pick up here and they've never heard one of these interviews before. Most student athletes are on a student visa, an F1 visa. What is the sort of definition of work under a student visa, the type of thing that they're not allowed to do?
Yeah, so I think to back up from that just a little bit, an F1 student visa does not come with employment authorization cooked in. It has very specific scenarios when a person might be able to apply for an employment authorization document if they are eligible to do so. And the reason why we're talking about employment in the context of NIL when it's not employment in the traditional sense is because the threshold question under immigration law is not the same as the labor question. Labor lawyers are always concerned with, are you an independent contractor? Or are you an employee? And for us, the threshold question is actually much lower because under immigration law, you're required to have employment authorization for any services that you render on U.S. soil, regardless of whether those are compensated within the U.S., outside the U.S. We had questions early on in the NIL era. Well, what if we just pay them outside the U.S.? It doesn't matter if the services are being rendered inside the United States. That's going to be a situation where employment authorization is going to be required. So in the early era of NIL, pre-rev share NIL, the quickest workaround that people came up with was let's take the athlete or the team, let's take them outside the US, have them shoot content outside the US, and we'll pay them for that content. And from a black letter law standpoint, that really does work. We have a few wild cards, and that is consular officers do have sort of unbridled discretion to deny a visa for any reason whatsoever, including if they feel it violates the spirit of the law as opposed to the black letter law. That decision is not subject to any kind of appellate process. So even the outside the U.S. workaround had its own level of risk worked in. So we always kind of frame it in terms of risk mitigation rather than risk elimination when we're talking about the F1 visa. And so then the question might arise, well, okay, so why don't they just go get work authorization so they can do it in the U.S.? And the reason why they can't is because, again, work authorization is only prescribed under very limited scenarios within that visa classification. So two of those scenarios are related directly to the course of study that the athlete is pursuing. So that's a internship that you do while you're still in school called CPT, or a postgraduate internship called OPT, where you're applying the skills that you learned during your degree program. So if you work in marketing, you might be able to do some NIL adjacent activities during your OPT or CPT process. But if you're studying, marine biology or education or something really unrelated to NIL, you're going to have a hard time getting your DSO at the International Student Office to buy into the idea that this would be an appropriate use of either of those categories. The other two categories are on-campus employment and economic hardship. So for athletes that are on full scholarships, it's going to be pretty hard to claim that an economic hardship exists because they're getting their housing paid for, their meals paid for, their tuition paid for. Economic hardship is really not liberally granted. We've seen it in scenarios where, maybe like the home country is in extreme political turmoil and like the parents are no longer able to send money back to the United States to help supplement the athletes' income in the U.S., to help them, just have some pocket money for spending while they're in the U.S. We've seen it granted under those circumstances, but really this is not a conversation about using that category for NIL. And the last remaining category is on-campus employment. Now, while that may be tempting because, sports happen on campus, sports also happen off campus. And that's why the on-campus employment authorization is not going to work for this scenario. So we're left with a situation where there's no available employment authorization type that would accommodate NIL type activities. So we're either forced to not take on those activities, or we're forced to look at potentially other visa categories that would allow the appropriate employment authorization and allow student athletes to pursue NIL activities inside the US.
Okay, before we get into the other visa types, I want to go back to a few things you said where people have said to me, well, but what if, okay, so I'm going to give you a few what ifs. First of all, I want to break down when you talked sort of at the beginning of this about services being performed, people think about like the plumber that comes to their house, delivering services. They don't see a post on Instagram talking about, the sports energy drink you like to drink as a service, but under the definition for an F1 visa, putting up a post for a brand would be considered a service, correct?
Yes, absolutely. There are different types of laws that might apply in these situations that might treat services kind of differently, right? So like tax law has a de minimis exception, as I understand it, for activities that you kind of do recreationally. It's not your full-time thing, and you might be able to treat that as passive income. That doesn't work for U.S. immigration purposes. So any amount of activity in the U.S. for which you are getting money is going to be that service that would then require employment authorization. So while it may not seem like work, it might seem more recreational if there's compensation tied to it, right? And sometimes even when there's not, if it's a service that others are typically getting compensated for, then it's going to be deemed to be a service which requires employment authorization.
Which really encompasses most of what we see in NIL, signing autographs, making personal appearances, the social media posts, the things we see most often would all sort of fall under that service. So then the next thing you mentioned that people bring up to me all the time is, okay, what if the student is a marketing major? Couldn't they just say all the work they do with a brand is goes along with their major? What's the sort of requirement? I mean, you talked about there being an internship. It's not really an internship when somebody is just putting up a few posts for a brand. Have you seen anyone sort of successfully navigate that where they're majoring in something like marketing and they've made it work for NIL?
Yeah, there have been workarounds designed around this idea of CPT. And in fact, my law partner, Dan Berger, came up with one of these for one of the institutions that he represents. And the idea is that, this is not a situation where you're just putting up your own posts and saying, okay, well, this falls under this employment authorization. You have to get buy-in from the International Student Office. They have to authorize it. And the way that this particular program was set up was they liaised with the academic side of the university, created a course that was something about entrepreneurship, marketing, leveraging NIL. And the students actually went through a course and actually learned specific skills. And it wasn't just about sort of making posts on your own behalf. It was broader than that. It was about just learning the skills of the ecosystem and being able to perform those services for others as well. So in that sense, there may be situations in which CPT could work. But again, I think we're really talking about times of the past, right? I think that we're, as we delve into rev share, and I know that we'll get into that a little bit more later on, those are all things that are probably less available to us.
You talked about athletes going outside of the country. I think Oscar Jibwe at Kentucky was one of the first examples of that we all really saw and were aware of, where they had a basketball tournament in the Bahamas and his agents were pretty open about the fact that they put together a bunch of brand deals before they went down there, and he created the content for those while he was down there. He also shot some stock images and videos that his agents could later sell on his behalf to be able to profit off his name, image, and likeness while he was still on a student visa. I know I've talked to you and other immigration attorneys before, and I know a couple of things you've cautioned me about, and you tell me if I'm missing anything. This is like a pop quiz for me. So you've got to be able to do it under the visa laws of the country where you are. So it would have to be okay under the type of visa you were on in the Bahamas to be able to do it. And then also you talked about, when you get before a consular officer, how quickly that goes, and being able to prove that you were out of the country and you weren't working in the US while on the student visa can be a potential complication there as well. Did I miss anything?
No, I think that's right. I think that's right. And I mean, when you're shooting content in the Bahamas, for me, the risk factor, particularly now against the backdrop of a very enforcement-minded administration, where a lot of people are getting put into secondary inspection as they're coming back with valid visas, right? So this isn't even about a visa application as much as it is, I have a visa on hand, I'm trying to enter the US, I'm still subject to inspection by CBP at that point in time, and CBP can choose to admit me or choose not to admit me, right? So imagine you're a CBP officer and you're going through this kid's phone and there's a bunch of content that appears to be of a marketing nature, right? You may go down the rabbit hole of clicking the settings button on there and seeing where that content was shot, or you may not. And again, these people have the authority to deny for whatever reason. They don't have to really explain it to you, nor is their decision subject to any kind of appellate process, because you don't really have a right to counsel at that point. When you're entering the US, even though you're physically boots on the ground in the US, you're not really considered to be in the US until you're admitted. So it's a situation where you're very vulnerable, and a lot of it is going to depend on what position is this person going to take, right? They're literally holding your future in their hands. And when they're looking at pictures and you can't tell on its face whether this content was shot in Florida or in the Bahamas, right? Because it's a 45-minute boat ride. I think you're putting yourself at risk. So what I've always told my athletes was, to the extent that you're doing that you're utilizing that loophole, I want you standing in front of the Sydney Opera House, Big Ben, some landmark that makes it very clear that you are not inside the United States. Make sure there's not one like it in Vegas so they don't think you're in Vegas, right? So Eiffel Tower, cross that off your list. But I think the more obvious on its face it is that the content was not generated inside the United States, the better. But even then, again, when we first spoke to a consular officer about her take on the Oscar Tshiebwe and Kentucky workaround, Amy and I, my co-author of the NIL and immigration book, were very confident that from a black letter law perspective, Kentucky had done the right thing and the workaround truly worked. But our friend, who is a former consular officer who has done thousands of consular interviews at different posts throughout the world, said, look, I could see a consular officer taking the position that this just violates the spirit of the law. You aren't supposed to be making bukus of money on your F1 visa, and so I'm just going to deny you, right? And then you can have an over-aggressive super fan from a rival fan base that, tries to take you out just because you're the star player for the rival team. There are those things that could ostensibly happen. And how do you prove, obviously it would be a terrible abuse of discretion, but how do you prove that that's what happened? And moreover, what is your opportunity for recourse, even if you can prove that that's what happened? And there's not, so that's the scary part about it.
Yeah,
in terms of visa,
you get denied entry, you have no opportunity to appeal. So what? You get sent back home, and when can you try to come back?
You could try to come back immediately. You could try to reapply for a new visa. So basically, when they kick you out, they usually cancel your visa. So you have to go back to see a consular officer and then convince them that, hey, they should grant the visa, which they're going to be kind of disinclined to do when you just got kicked out, right? Because there's sort of this deferential treatment of that decision just as a part of their internal professional courtesy. So you're going to have to really make it fundamentally clear that whatever happened at the border was an abuse of discretion, that you're not actually inadmissible, that you're not doing anything wrong, and and maybe the guy just hated you because you're the star player for the rival team.
Yeah. You and I have talked before about the idea of passive income opportunities. This gets discussed a lot in this space. And a lot of what's brought up is things like group licensing, where your name's on a jersey or you're part of maybe a trading pack of trading cards, and you've licensed your name, image, and likeness to be part of these things along with everyone else on your team. But you're not promoting it. You're not putting it on your social media. You're not talking about it. You've just licensed it. And you always tell me this isn't about eliminating risk. It is just about sort of mitigating and doing the lowest risk opportunities. Tell people a little bit about what people have tried with those passive income opportunities and what you think works and what doesn't.
Yeah, so I think licensing in its clearest form probably works, again, from a black letter law standpoint. So it is defensible because there's no specific service that is being rendered. Now, we have to be very careful, right? Because there are opportunities for a slippery slope argument here. And that is, okay, so there are trading cards, but are the trading cards just captures of, game time? Or was there a photo shoot set up to create content for those cards, right? If we're talking about, a jersey or a tumbler or something else with your name on it that's being sold, Campus Ink, for example, like, right? They do branded products, and I love their model, and I think that it's a smart model and it works. But I think it's also very, very difficult to control the impulses of a 19 or 20 something year old kid who understands that the amount of exposure that this product gets directly affects their, the amount of money in their pocket. And, to really communicate to them the level of risk that they face by telling their friends online or offline to buy it, right? I think is tricky. And you really have to consider whether the athlete can handle that guidance and can follow that guidance. So yes, but if executed correctly, that can be done. And and people always kind of frame it in terms of group licensing. I don't know that the group or individual makes a difference, right? Again, if you're group licensing, but you're promoting it, right? Or if you're creating content for the licensed product in the US, you're just as liable as if it were done on an individual basis. So that doesn't necessarily give you cover. So I just want to kind of make that clear.
Okay. Speaking of licensing, you and I were at the NACTA convention last week, and there was a lot of discussion about schools that are framing revenue sharing as licensing as a way to cut international athletes in on revenue sharing. And you and I have talked about this a lot, so I'm not sure where to start because I think there's a lot here. But give us kind of high level the problems you see with compensating international athletes with revenue sharing and calling that licensing.
So there's a lot to unpack here, but let's kind of go to the agreements themselves, right? I think that the reliance on this licensing argument is sort of an extension of what we just talked about in the third party context, right? So a third party comes in, they license a product, nobody's promoting it, nobody's providing any services to create it. The money is directly tied to the sale of that product. That's a very classic licensing deal, right? What we're seeing in the context of these rev share agreements between the institutions and the athletes themselves is they want to use the same terminology, but for a fundamentally different set of deliverables and circumstances. And that's why I think it fails, because fundamentally it's a form over substance argument. And we as lawyers know that courts don't care what you call it. They're going to look at the four corners of the agreement and they're going to evaluate the relationships between the parties. And the central question to the rev share agreements between the athletes and the institutions is going to be, what is this money really for? Not what are you saying it's for, right? But what is it actually for, right? And as you consider the substance of these agreements, where the compensation is in whole or in part dependent on whether you utilize a voluntary red shirt, whether you transfer schools, whether you attend team activities, whatever you want to call it, there's a very clear connection between your availability to perform services as a student athlete for a particular school and the compensation you're receiving. And unless you're able to silo that off and say, well, no, we're going to pay you even if you do transfer, or even if you do miss games, or even if you do miss team activities, then you're making it clear that you are compensating them for those services, right? And so no institution that I'm aware of has been willing to say, well, we're not going to, we're going to pay no matter what, right? We're going to pay even if you transfer, even if you miss activities and things like that, right? And, and the argument, which again, I think fails, is sort of like, well, your NIL is reduced when you don't participate in a season. But there's no attempt to include a metric that attempts to analyze by how much, right? Sure, your NIL might be reduced, but is it reduced by 100%? Is it reduced by 50%? Is it reduced by 20%? Or maybe it increases, right? Because, hey, they might be in anticipation of this new quarterback that they're getting, right? And the kid's sitting out a redshirt season, and the wide receivers get better over the course of next season, and the talent's really good, and the other building blocks of a roster are really coming together, and this team is going to be in line for a national championship run next season, not this season. And that builds up all the hype about this quarterback that they just got, right? I mean, that's kind of how I'm thinking about it. That just makes logical sense. So it's not always true that NIL values reduce. That's an assumption that is being made, and I think it's an assumption that really isn't so much of an assumption as an obfuscation of the reality of the nature of this agreement. And from an institutional perspective, I get it. I understand that this is an absolute compliance nightmare for you. I understand that we want to shift the compliance burden as much as possible. We want to avoid calling this employment. We want to avoid calling this labor. But, are we going to be able to do that in a way that actually prevents enforcement? I don't think so, at least from an immigration standpoint.
Have you seen a revenue sharing agreement or heard of one yet that you think successfully allows an international athlete to receive revenue sharing?
There's no way that that is possible on an F1 visa. There's no language you can put into your rev share agreement that makes it compatible with an F1 visa, and that entirely eliminates the risk. No matter how much you want to shift the compliance burden to your athlete, because at the end of the day, the DHS regulations also say that if you as an entity or as an individual obtain the services of an unauthorized alien, meaning a person without employment authorization, whether by contract or through employment, you are now liable, and you are exposing yourself to liability and penalties and things like that. So the institutions, I think, are unaware of this. And to the extent that they are aware of this, they think the language is going to cover them. And if they don't entirely think the language is going to cover them, they don't think the government is going to come after them. And I want to speak to this point because, there are schools, particularly the Power 4 schools that, have a sense of security, right? Like they're so big, they're so influential, they're so important to the economies of the states that that they're situated in, that they feel like it would be an absolutely insane development for DHS to come and say, hey, we're going to strip you of your right to be able to, to host this star point guard that you have, or a star quarterback or punter, kicker, whatever. And I think that may be right to some extent, but here's what we need to understand. We know that there are certain institutions that this administration has a bone to grind with. There's been a list that's been circulated. There are a few surprises on that list. And, while the University of Alabama probably is not on that list, we can look to schools that both have let's say political opinions that are not cleanly aligned with the administration's current priorities, and have a pretty robust athletics program. My law school alma mater, Cal, being one of those places, right? I mean, it's not an Alabama, it's not a Tennessee, but it's up there. It's a decent athletic program. And, and it's a school that I think is politically at odds with what's happening and what the Trump administration seeks to implement as far as its agenda. So when you have a school like that, right, No, I don't think they're going to come after Alabama. But the problem is Alabama's not safe if Cal isn't safe. And here's why. If they come and they say, look, the rev share agreement between Cal and their basketball athlete or their football athlete violates the F1 visa regulations, they can't then say, but it's fine at Alabama.
Right.
Because that's inconsistent and disparate application of the law, right? So Alabama is not safe because Cal is not safe.
Yeah, that makes sense. So I sent you a tweet I saw right after we left NACTA, and it was a quote from NCAA President Charlie Baker that essentially said, he didn't see why student athletes, who were on student visas couldn't do revenue sharing. Sure, they could. And, he was going to talk to lawyers and look into it more. And I think that has further fueled these schools that think they figured out some kind of loophole for offering rev share to international athletes, that because, he said it, then there must be a way. And you're not the only immigration attorney I've talked to about this. I have yet to talk to one who agrees with him. So I don't know if you have anything to add to that. I mean, he didn't give a whole lot of context other than he seems to think it's no big deal.
Yeah, I mean, I think the NCAA is in a difficult position, right? They want to sort of eliminate, or at least attempt to eliminate, some of the post-house chaos, because it is chaotic right now. And they want to give their member institutions comfort that there's some way forward here that works. Again, I don't know of any immigration attorney who is knowledgeable about this space that believes that rev share is compatible with an F1 visa. It's just not. And there are few of us that work in this space, in the sports immigration space, even fewer of us who work in the NIL and immigration space. And, and again, we're all talking to each other. We have weekly calls. We have a Friday 2:30 p.m. call where we're just discussing this stuff. And, we've been thinking about it for not months, for years, right? We've been going at it from different angles. We've been involved in drafting legislation. And the reason why we've been involved in drafting legislation is because we are all in agreement that that's what it's going to take to create a legal avenue for compliance, because one does not exist right now.
The one thing that some student athletes, a small group at this point, have been able to do is to get a different type of visa so that they're not on that F1 student visa. Can you tell people that the P1A seems to be the one that most the student athletes who are getting them, that seems to be the type they are getting. Can you tell people what it is and what it really takes to qualify for that?
Yeah, so the P1A, when I first started using this visa, I got a lot of skepticism because the visa is traditionally utilized for professional athletes. And so, there were people that were saying, oh, you can't do that because they're amateurs. They can't be professionals, that would violate the NCAA rules. And that's absolutely true. They are not professionals. We're not presenting them as professionals, but the P1A regulations have different silos, so different types of P1A classifications that you can apply for, one of which applies to professional athletes, which are, your team and league sports primarily. So you're talking about your MLB, NBA, NHL, NFL athletes. They're all in that one. And then there's a visa category under the P1 called the internationally recognized athlete. And that one is available to both professional and amateur athletes alike. It does not create a distinction between the two. What you have to demonstrate is that you're internationally recognized, which is, in many ways a tougher prospect for an amateur athlete, but not impossible, particularly for athletes who have played for a national team, have competed internationally, separately from their NCAA career. And the reason why I knew this was a viable option was because I got my start in sports immigration in track and field visas, work with a lot of track and field athletes. And prior to the NIL era, what I was encountering a lot was a situation where I would have a track and field athlete that would have exhausted his or her NCAA eligibility, but still had scholarship money. So they wanted to pursue a master's or finish their undergraduate degree, but they were ready to also start competing on the professional circuit. And professional circuit is kind of a misnomer for track and field because most of them are not making money at this stage in their careers. But they are competing against pros for prize money at both professional meets and sometimes at collegiate meets when there is no prize money. But they do transition to that portion of that career. So I needed something where they could go to school full time, right? Because they still wanted to do that, and they could compete, and they can make money from competing. So we used the P1 for that scenario. Now, when NIL rolled around in 2021, I knew that I could transition some of these athletes to a P1, have them be going to school full time, have them be making money, because it is, you can make money as long as it's tied to your activities as an athlete on the P1. So we started doing these for different types of athletes. And over the course of the last few years, we've gotten them in, a variety of different sports. We've gotten it for golf, tennis, swimming, fencing, track and field. So really like a broad representation. But the area where they seem to be pushing back pretty significantly for whatever reason is basketball. And full disclosure, I have tried 2 basketball visas over the course of the NIL era. One of them was for a male athlete. He ended up actually withdrawing his application before it went to decision, so we don't know what would have happened with him. And then I had one for a female basketball player, last year, Poa from LSU. She was on the national championship team there. She guarded Caitlin Clark in the tournament. She was also denied, and she was denied for reasons that I believe are unfounded in law. And for that reason, Amy Maldonado, my co-author on the NIL and immigration book, and I decided to sue the government in federal court, utilizing the appellate authority that the federal court has to review a final agency decision under the Administrative Procedure Act. And so the reason why that case is something that everyone in the NIL world needs to be paying attention to, and it's filed in the Middle District of Louisiana. You can look it up with her name, last year, Poa, you'll find it. It's sealed to the extent that it's not available on Pacer, but if you go to the courthouse, you can get the documents. So the reason why this is a case that everybody needs to be talking about is because of the government's argument. They made kind of 2 arguments in this case, one of which is laughable and preposterous, and the other one of which is dangerous and potentially really consequential. The laughable and preposterous one was that they concluded that the ability of last year Poa to monetize her name, image, and likeness had nothing to do with her status as an athlete at LSU.
You're right, laughable. Yeah.
Laughable, right? The second point that they're making, and this is the reason why everybody needs to be paying attention, is they're trying to say that student athletes in the NCAA are not eligible for the P1 visa as a matter of law. And that is consequential for everyone, because right now, we're in an environment where the F1's really incompatible with rev share. But even if you take out the rev share component and you're talking about third-party NIL deals through collectives or private sponsors or whatever, we still have a major F1 problem, right? F1's visas are under attack by the administration. Schools are losing their F1 privileges. These visa interview scheduling appointments are being suspended. So there's a lot going on with the F1 that makes it kind of a bad place to be right now, right? So if you're thinking, okay, cool, I'm going to shift from the F1 into these P1s, that's great, right? If you can get the P1, that's wonderful. And that's why what I encourage everyone to be looking at right now. But again, this case could ultimately decide whether there's any avenue for compliance that schools have now, right? Because right now that avenue has not been foreclosed, right? We still believe that the P1, pending, any legislation, policy, regulation that says otherwise, the P1 is still available as a means by which a student athlete can go to school, can compete, and can make money from their status as an athlete. But if the POA case does not go as we hope it will, that avenue for potential compliance could be cut off. And then we're left with nothing, right? Then we're really in a situation where the schools are going to have to start to go to Capitol Hill and say, hey, we need a solution. And actually, from my perspective, we need to start doing that now. Because, the P1, it's great. I love it. It's a visa that's available to, I think, most athletes who would be eligible for rev share, but it's not a panacea in the sense that not everybody who's a student athlete in the NCAA will be able to meet the threshold criteria for the P1. So we're still leaving out in the dark the vast majority of student athletes who are going to the same practices, competing in the same games, putting in the same amount of work as their US counterparts and are just not able to monetize that effort in the same way as their US counterparts. So for me, this is the question of equity, right? I know that schools may not be willing to go to the Hill about this until it hits the revenue generating sport athletes, but this obviously has broader implications.
There's so many issues already, and we're creating new ones sort of as we move into revenue sharing. One thing I've talked to you about, and we talked about it on this panel last week, but I want people here to hear it as well, is given the current system and the fact that we don't believe there's any way for current F1 visa holders to receive revenue sharing, you've also brought up a concern with them just being on the same team where everyone else is receiving it. So even if the international athlete isn't getting rev share, if every other athlete on the team who's not international is getting it, can you explain to people why that's potentially a problem as well?
Yeah, so this is kind of an area that's quite nuanced. It's probably the most nuanced area in this whole big mess of questions that we're trying to untangle and unravel. And the reason why it's the most nuanced is because there's actually no authority that supports that proposition. There's no law or regulation that I can point people to and say, hey, this is the black letter law that prevents you from being able to do that. But in practice, what we have seen as practitioners over the years is that DHS does not perceive the ability to volunteer for a position that is typically paid as a workaround the employment authorization requirement. And the reason why, if you kind of try to unravel the logic behind it, is their assumption is going to be, well, if you're volunteering for a position that everybody else gets paid for, you're probably getting paid just, in an envelope stuffed with cash under the table. And so
it never happens in college sports. I have no idea what you're talking
absolutely
about.
So they want to avoid that. And the closest thing to authority on this point that I can point people to is if you go to the international student websites for most institutions, it will have like in their Q&A, hey, don't volunteer for things unless you have employment authorization, if this is typically something that is compensated or you're not doing it for credit or something like that. So it gets really tricky really fast. And I think there's a lot to unpack, but I think, all of this starts with the institutions really needing to recognize how much of a pickle they're in when it comes to the immigration stuff.
So I've got some questions that came in from parents and from some folks who follow on social media and knew we were going to talk today. I've seen a few different parents in some recruiting groups that I'm in where I provide NIL education, asking the recruiting experts about their international student athletes who are coming for the first time this fall. They're going to be freshmen this fall, and they haven't had their visa meetings yet. They've been pushed back because of things that have happened in the course of this administration. And now they're getting nervous that it's not going to happen in time for the school year. Do you have any advice for the parents or for the coaches who are still sort of waiting out this situation as well?
Yeah. So I think institutions, depending on, how much weight that institution has, can do two things. One is obviously contact their congressional representatives and their senators. And two is leverage connections with the Department of State sports diplomacy section. There's kind of a point person / department within the Department of State that handles like the intersection of sports and immigration. So that may be, that may be a department that a relatively influential school could reach and try to push these through. Now, per my partner, Dan Berger, who's much more closely connected to the higher ed, like F1 visa space, he's saying that he's seeing some of these appointments start to become available, but whether that's worldwide or it's post specific, what the volume is, it's really hard to say. I think it's safe to say that anyone who's going to be getting an appointment is going to be subject to extreme vetting, right? Which is not only a review of their social media and things like that, where the purpose here, because this is part of a larger effort to kind of capture individuals who, again, have protested or have views that don't align with the current administration. They're going to be looking at social media. Well, if you're an influencer, right? If you're a student athlete, if you're monetizing your NIL or plan to monetize your NIL, there may be things on your social media that may be concerning to that consular officer, right?
Or in
And
the
that,
press. Like I was on a show this morning, Morning Cup of Hockey, and they were talking about a hockey athlete that they had heard was getting either, I think it was 200,000 or 250,000, and they were asking me how is it possible, how are they getting that? And I don't know the specifics of what that looks like, but I'm assuming it's some combination of NIL money from the collective and potentially even revenue sharing. Having articles out there, or people talking about how much money you're getting, I mean, that sounds to me like that could come up if they're Googling your name and that's what's coming up, that could be problematic for a student to explain.
absolutely. And I think this just underscores the fact that the F1 visa is no longer, this like safe and easy visa option that it used to be. And, in terms of the timing, I don't have answers for that. If anybody has, if anybody's telling you they have answers for that, they're lying, because nobody really knows. And, do schools need to be thinking about, okay, well, if what happens if we don't get an F1 visa appointment for our incoming freshmen? And that's where I really think they need to think about these Ps, because the Ps are not subject to the F bans, at least, the visa interview stoppages. Now we have, for certain countries, we have the geographic visa bans to contend with, and that's a whole separate mess that will affect certain schools and certain athletes. There's at least on its face sort of a reference to a potential waiver type procedure that is in the proclamation that sets up the visa ban from the various countries, but it's not clear to me that a process has actually been designed and made public. And actually, as we know from the first Trump administration, the Muslim visa bans, my friend Chris Richardson, who's a former Department of State employee, a former consular officer, he actually blew the lid on the Department of State in the briefing for the Supreme Court case on the Muslim ban, where he disclosed that even though the proclamation said that there was a waiver procedure, there was in fact no waiver procedure that was designed by the Department of State, and there was no process by which people could apply for a national origin waiver to those first Trump era travel bans. So it's hard to say. It's really, really hard to say. We're certainly in uncertain times, and I think schools need to be planning out their contingencies and figuring out like what are they going to do if they can't get the athlete here.
If people want to pursue a P1, about how long does that usually take? I know things are kind of shifting now, but how long should people prepare for to be able to?
So there are two kind of timelines that we're concerned with. There's a first step and a second step. The first step is where we submit documentation to the Department of Homeland Security by mail. The athlete does not have to be here for us to do that. And that's just basically a packet that outlines, the athlete's achievements and their plans here in the US. And if the government approves that, the second step is going to be scheduling the visa interview and actually getting the visa stamp. The only people that are not subject to that second step are Canadians. And that's actually something worth noting for athletes kind of subject to some of these F1 restrictions, right? If you have Canadian athletes, you can just bring them in, right? Like you're not worried about the visa scheduling because they don't need the visa. You issue your I-20 and they can come in. But for the rest of these folks, they do need a visa to be able to get into the country. And so they need either an F or, as the case may be, a P visa. So they're going to need to schedule that appointment. So for the first step, if we utilize the standard processing timelines, it could be anywhere like from a few weeks to over a year. It's very chaotic. For the exorbitant price of $2,805, and by that I mean $2,805, not $28.05. We can get a decision or a request for additional evidence from the government in a matter of 15 business days. If they issue a request for additional evidence, once we submit a response, they get an additional 15 days to give us a decision. And that's just the first step. Okay. we still have to schedule the visa interview, and that's going to be dependent on consular availability. That's where, again, the P4 institutions can really, utilize their weight and their influence with congressional offices to try to get those visa interviews scheduled more quickly. But, again, the timeline for that is relatively uncertain as well.
Okay, I'm going to go to a few questions I had come in here on social media. I know you've seen some of these already, but I thought this one was a good one. And I've seen this come up. You and I think, have discussed this before. For revenue sharing, is there a workaround if you put the money in a trust account and don't release it until the athlete is back in their home country or has completed their time here in the US?
Nope. Because we don't care how or when or if the athlete is compensated. We care if the athlete is rendering services or labor on U.S. soil.
Okay. A good question that came in from my friend Katie Davis, who sat on the panel with us last week, but I don't think she asked this when we were all in person. She said, does the P1 have to be sponsored by an institution? And if so, is that a possible retention strategy during portal season?
So no, it does not have to be sponsored by the institution. It can be sponsored by the institution. And I think to the extent that it is, it can be used as a retention strategy, right? Because the petitioner kind of holds the cards to the status. So if you had a P1 that was filed by Tennessee and you're now transferring to Florida, Florida would need to, either put you on an F1 or get you a new P. And that's a process, right? So to some extent, like tying that petitioner status to the athlete and their, the ability to maintain status in the U.S. Certainly, not a solid retention strategy, but is a factor for sure that could be utilized.
Anything else we haven't talked about that you've seen people bring up as sort of workarounds, or what if we did this? What if we did? I feel like I get a lot of the what ifs. We've hit some of the big ones already, but anything we haven't hit?
I think we've hit the big stuff for sure. I think that's everything, at least that I've seen, right? I think we always kind of learn from the audience as well, and people always come up with something new. And
people get creative. You have to give them bonus points for that. Some of the ideas people send.
Yes and no. So in terms of creativity,
a bit dangerous.
Right. I consider myself a creative advocate, and I've definitely been, the type to push the envelope. Obviously, using P1s for NIL was not the design use of that category. So I'm not going to say I don't ever push the envelope, but I also started doing that under a much more immigrant friendly administration. And I think right now, as we consider creative strategies, we have to really be mindful of the potential consequences and the burdens of sharing those consequences if things go wrong, right? And are we willing to actually to shoulder those adverse consequences if that materializes?
That reminds me of one more question. Actually, when I was on the hockey show this morning, Morning Cup of Hockey, they were asking me about, okay, what if you were a student athlete who does end up, worst case scenario, you got caught up in this, you got denied coming into the country, you weren't able to get back in. What happens a year or two from now when you want to come back and you want to play in the US for the NHL?
Yeah, so that's a great question. And I think, the major leagues really have a lot of sway. Like they are, they usually have sort of their own back channels to the Department of State, and they can get things done. So to the extent that, a person has not done something that renders them really inadmissible, and even if that happens, there are waivers that can be applied for. I feel like, if you can get that major league deal, then you're in a good position to kind of, to help erase the consequences of what happened in college. But it may not be quick. And, and you may lose some money in the process, right? Just in terms of opportunity costs and things like that. Or, a team might just pass on you because they don't want to deal with that mess. And that's reality, right? So I think, you do have to be mindful of the fact that could this potentially cut off your opportunities? Certainly the concern, I think, is bigger if you're not in a sport that feeds into the major leagues, right? Because if you're a track and field athlete that got caught up on all this, swimmer, gymnast, I don't really see an entity that is going to advocate for you in the way that the major leagues would. And even if they did, I don't know that they have the pull to help you.
All right. I think that's all the questions I had come in. I'm sure people will think of more that they'll send us, and maybe we can answer those over social or do this again sometime. I feel like I've got like an associate's degree in immigration law after all the times I've talked to you. I always tell people I know just enough to like talk big picture, and then I tell them to call you. So thank you for educating me and all the rest of us on this.
Always appreciate the conversation. Thank you, Christy.
Big thank you again to Ksenia for joining us to chat more about international student athletes. You can find even more of her advice, including some case studies and scenarios, in my brand new book, The Athletes NIL Playbook. It was not supposed to come out until July 2nd. It's what I've been so busy with that I haven't been podcasting for most of the last year, but it's out already. My publisher decided to go ahead and release it early because of the House settlement, and so it released this past Tuesday and is available at every major retailer online and hopefully in a bookstore near you soon. So I hope you will check out the Athletes NIL Playbook.